Today I'm going to talk about custody in either a divorce case or just a regular custody case. And a regular custody case takes place when the parties are not married, but they have a child together. So in custody cases, there's two types of custody. There's legal custody and there's physical custody. So legal custody is all about which parent makes decisions about where the child's going to go to school, what doctors they're going to go to, religious upbringing, things like that. In almost all cases, legal custody is joint, unless there's some compelling reason where legal custody can't be joint. So the parties, usually it's when one parent just isn't fit to make decisions for the child, or maybe they're not involved in the child's life at all, or if the parties can't get along at all and things are tremendously contentious, then there might be sole legal custody to one of the parents, so that somebody's making a decision for the child or children. Or it can be joint legal custody with final decision making to one of the parents, where they have to try to work together to reach an agreement, but ultimately if they can't, then one party has final decision making. And that's different from sole custody. When one party has sole custody, they don't even have to talk to the other parent. They can just make unilateral decisions. So joint legal custody, final decision making to the one parent is a little different than sole legal custody. So that's legal custody, and then there's physical custody. So physical custody is all about where the children are, what the visitation schedule is going to be. It can be anywhere from primary residence with one parent and the other parent doesn't have any visitation, or a pretty common schedule is primary resident with one parent where the other parent has, where the parents alternate weekends, Friday to Sunday or Friday to Monday or Saturday to Monday, whatever parents decide on. So alternating weekends, and then maybe the non-custodial parent, so the parent with whom the children do not live, may have a dinner visit every Wednesday, for example, or they may have an overnight once a week. So it's kind of more of a primary residence schedule, or it can be a 50-50 schedule where the parents, one parent has every Monday to Wednesday, the other parent has every Wednesday to Friday, and then they alternate weekends. But really at the end of the day, parents can agree on whatever parenting schedule they want to have. So that's the difference between legal custody and physical custody. And the statute that dictates all of this, let me share my screen, is 46B-56. This is the statute that covers custody. And the important section is right down here. So subsection C, in making or modifying any order as provided in subsections A and B of this section, the court shall consider the best interest of the child. So that's really what custody comes down to. It's almost always, you'll hear this phrase, it's a term of art, it's the best interest of the child, which is a pretty common sense term. The court's going to award legal and physical custody based on what the court feels is best for the child, or ideally it's the parents reaching an agreement. So it's what the parents agree on is in the best interest of the child or children. And then there's a number of factors that the court can consider in determining custody, and those are all right here. I'm not going to go through them in detail, but they're all listed. So you can Google this statute and find it online and read it in more detail. So practically speaking, how all this works is, when a divorce case is initially filed or when a custody case is filed, you're going to want to file a motion for custody and visitation pendente lite. So here's a sample motion, and it's basically saying the plaintiff or defendant hereby moves the court to order joint legal custody, primary physical custody to the plaintiff, and visitation to the defendant. Obviously, you can request whatever you feel is appropriate here. You may be requesting sole legal custody, or you may be requesting joint legal custody with, final decision making to one parent. or, you may be requesting primary physical custody or joint physical custody, et cetera. There's all sorts of different requests. So you want to file this pretty early on in the case, just so that you get moving on working out custody. In any divorce case, you're going to want to work on custody as soon as possible. You want to figure out if there's going to be any long-term custody disputes, because working out custody can be very time-consuming. And ultimately, if an agreement isn't reached, then there's some services that the court offers or the parties can obtain on their own that can help them work out custody. So practically speaking, a penente lite motion for custody is filed, and then the first step is to meet with family relations. Well, I guess you don't necessarily have to meet with family relations. If the parties can just reach an agreement, then they can just write out what their agreement is and enter it with the court, and it becomes a court order. But assuming there are some custody disputes, how it would first work is that the parties would meet with family relations, and both sides would say what they have to say about what they think should happen with regard to legal and physical custody. And the family relations office, which is basically a neutral office that works at the courthouse, you'll work with a family relations worker, and they will hear what both sides have to say about what should happen with legal custody and physical custody. And they'll try to help you reach an agreement so that you don't have to, drag out the court process, go through litigation, etc. So they'll try to hear both parties' concerns and help you reach an agreement on these issues. But ultimately, if an agreement isn't going to be reached, then there's a number of services that the family relations office can offer. Usually the most basic first step is to have what's called just a mediation. So the parties will, the first meeting with family relations is usually pretty brief. It's a half an hour to an hour, where there's only so much you can work out in that limited amount of time. But if the family relations office is hopeful that with some additional time, they'll be able to help you reach an agreement on your case, they'll schedule you for a mediation, where it's more in-depth sessions with family relations, where you and your spouse will meet with family relations and have, they'll take more time with you, hear about the issues, and try to help you reach an agreement. Now, ultimately, there are certain cases where that just isn't going to work. The parties are never going to agree. And in that situation, family relations can offer some additional services. And ultimately, their most in-depth service is a comprehensive custody evaluation, where they will meet with the parties individually, they'll meet with the parents individually, they'll meet with the kids to the extent that meeting with them is relevant. Obviously, if it's a newborn, they're not really going to do that, although they will want to observe each parent and their interactions with the child. They'll meet with any third parties that the parents think are relevant. So, relatives, school providers, babysitters, doctors, etc. They'll either meet with or talk to those people. And ultimately, family relations will make a recommendation on what they think should happen with regard to legal and physical custody. So they'll do an evaluation and they'll put together a written report, and then they will present that to the parents. Now, after that written report is presented to the parents, ideally, the parents would agree, would be able to reach an agreement, because ultimately, if you can't reach an agreement, you go to a judge, and a judge makes a decision. Now, the judge is generally going to follow the recommendation that is in the family relations comprehensive evaluation, because the family relations office is a neutral party who, has taken some time to meet with the family, and, they don't have any skin in the game. So the court's most likely to follow the recommendation of that neutral party who knows the most about this family. So because of that, cases are more likely to settle after the custody evaluation results are presented, because, parties generally know, okay, the court's probably going to do what is recommended in the custody evaluation. Therefore, let's try to settle this case rather than having to go to trial. So that's the family relations route. Now, a custody evaluation by family relations, it can generally take 3 to 4 months. It's a very extensive, drawn-out process. Now, you can take a separate track from a family relations evaluation, which is by having a guardian ad litem appointed. So a guardian ad litem, it's a GAL is short for guardian ad litem. They represent the best interest of the child, and they are a neutral party. It's usually an attorney who is appointed, who will do a lot of what I just described as the services offered by family relations in a evaluation. They will meet with the parties individually. They'll meet with any relevant third parties, and the GAL will make a recommendation about what should happen with regard to legal and physical custody. Now, a GAL, there's generally a cost associated with it, where you have to pay an hourly rate, usually a retainer and an hourly rate for the GAL. There's not always a cost. There are some organizations that offer free GALs for people who qualify based on income. But the benefit of a GAL is, they may have a little bit more resources and time to spend with the family, but it's also generally going to be quicker. It's not a 3 to 4 month process. They can dive in and gather information more quickly and make a recommendation. So a comprehensive custody evaluation is pretty similar to the GAL route. And again, with a GAL, the GAL is going to make a recommendation at the end of their investigation, and that recommendation is going to go to the parties, and hopefully the parents can reach an agreement after hearing the GAL recommendation. Because as I described before, if you have to have a trial, the GAL recommendation is going to go to the judge, and the judge is generally going to follow that recommendation because, again, it's a neutral party making the recommendation. So those are the family relations and GAL tracks. Now, at the end of the day, if you can't reach an agreement with the help of a GAL or family relations, then the final step is just a trial. And a trial is, where it's like you see on TV, both parties, everybody goes in front of the judge. There's testimony, evidence presented, witnesses who testify, etc. And everybody presents their case about what they think should happen with regard to legal and physical custody. And at the end of the day, the judge makes a decision, and that decision is binding. Ideally, it's always best to reach an agreement in your case because you have control, and you can work with your spouse to the extent that you're able to, or your ex-spouse, to try to tailor an agreement that works for both of you. You don't want to go to trial because at the end of the day, there's some third party who's making a decision for you, and it takes a lot of the control out of your hands. That a judge isn't going to necessarily take the time to tailor a order that works for both of you. A judge doesn't know your family as well as you do. So that judge is going to make a decision that, neither one of you will probably like. So it's always best to reach an agreement in a custody case.